the conference room. Anyone that's going to be testifying today, if you go ahead and give me your name and tell me who you're representing.
Yeah, my name is Mike Malk with RWA Architects.
Hi, Mike. Is it M-A-U-C-K?
H on the end, M-A-U-C-H. Thank you.
Got it. Sure.
Alice Leach, RWA.
Okay.
And then Jordan Elliott, RWA.
Okay. Welcome.
Thank you.
Looks like we have someone else trying to join now. I see we have Molly Bruges. If you could unmute and tell me who you're representing here today.
I'm Molly Brugge. I'm representing myself with RWA.
Okay, got it. All right, owner. Welcome. See, we have Mr. Burley. Welcome.
Good
If you could
afternoon,
walk me through
Mr.
who's with you there.
I'm here with Anthony Wood and Lori Wood.
Okay, and you're representing them as their attorney in this.
Yes, sir.
It was Anthony and
Lori Wood.
Lori Wood. Okay, welcome. And these are adjacent property owners, is that right?
That's correct. They are directly to the east of the subject property.
Got it. All right. Thanks, Mr. Burley.
Welcome.
So we have Wes Menzel, our zoning plans examiner, who's present. Hi, Wes.
Hi, David.
And Kevin Brugge, is that right? Brugge, okay. Are you another property owner? You're the owner of the property.
Yes.
With
Yes,
Molly?
sorry.
Okay, sure. All right, welcome everyone. On the applicant owner side, are we expecting anyone else to join us here today?
No, sir.
Okay, let's go ahead and get started. I need to read through our hearing script. This will basically just cover the procedure for the hearing, and then we'll get started. So this is the June 14th, 2023 session of the zoning hearing examiner docket. My name is David Sturkey again. I'm the zoning hearing examiner. The case before us today is case number ZH20230077. That's 3453 Principio. The purpose of this hearing is to allow applicants and opposing parties to testify and to offer and refute evidence and testimony. This hearing will follow the rules found in the zoning code and the supplemental rules of the zoning hearing examiner. All testimony and evidence that an applicant or any opposing party wishes to offer must be presented at this hearing. The hearing will proceed as follows. The applicant, the applicant's attorney, or the applicant's agent will first present the applicant's case. Anyone from the public will have an opportunity to speak after the applicant has presented its case. If the applicant is represented by an attorney, the applicant's attorney may cross-examine any person who has testified at this hearing. If a party of record is represented by an attorney, the attorney for the party of record may present witnesses after the applicant has presented its case and may cross-examine any person who has testified at the hearing. In the event that any party testifies or offers argument in opposition to an application, the applicant will have an opportunity to rebut that testimony and or argument that was offered in opposition. After the applicant has been given an opportunity to rebut any testimony and or argument offered in opposition, any attorney for a party of record will have an opportunity to make a closing statement. And then finally, the applicant will have an opportunity to make a closing statement. After all presentations have been made, I will close the hearing. Decisions may be expected within 2 weeks. I may limit or exclude any testimony that I deem irrelevant or outside the scope of the application being considered. I may interrupt any speaker to ask questions or make any comments. In the event of any technical difficulties with the Zoom technology, I'll do my best to troubleshoot those on the fly, but to the extent there is some defect in the tech that prevents us from meaningfully going forward with this hearing, I may continue or postpone the hearing at my discretion. Okay, now I just need to swear in all of our witnesses. So if you intend on providing any testimony here today, making any comments, asking any questions, really doing anything other than just strictly observing, then the zoning code requires that I swear you in. So if that's you and you are not an attorney, I'd ask that you take yourself off of mute now. Need everyone to raise their right hand and to answer out loud. Do you solemnly swear the testimony you shall give will be the truth, the whole truth, and nothing but the truth?
I do.
Yes.
Yes.
Okay, great. So I have, just for the record, everyone sworn in except for Molly Brugge. If you change your mind, you are welcome to be
I
sworn
think
in
I
later.
had my hand too low. Sorry.
Okay, yeah, I need you to go off mute and raise your right hand. Do you solemnly swear the testimony you shall give will be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, great. Thank you. Okay, let's see. Will the folks at RWA be taking the lead here on the presentation from the applicant?
Yes.
Okay, floor is yours.
All right. Thank you. For those of you who don't know anything about us, RWA has been practicing residential architecture for 34 years in Cincinnati, Hyde Park, Mount Lookout area, as well as other areas across the country. I specifically am on the Hyde Park Zoning Committee and familiar with zoning applications in the city of Cincinnati, as well as applying for successful variants over the past 3 decades. RWA is known for its design reputation as well as its thorough attention to detail. I think that's why the Bruggies came to us to help them with this design issue. Before I get started, I'm interested in knowing how many people submitted comments. Is that something you can tell us?
Yes, to my knowledge now. And do you mean comments outside of, you mean from like neighboring property owners or anything like that?
Yeah. And how many opposed and against?
So I have the written opposition that was submitted by JP Burley on behalf of his clients. They came in yesterday that I uploaded to the project docs file. Outside of that, I don't believe that I have any other statements of opposition.
Okay, thank you. And then,
Sure.
So maybe start with some history about this project. The Bruggies came to us in August of 2021, looking to provide more space for their family. RWA looked at a number of alternatives for ways to expand. We looked in the basement. We looked towards the front, to the sides, to the rear. You know, the basement had its own issues. That we had contractor price different options and things like that. It just didn't make any sense to go down for this space. The house has been added onto numerous times over its lifetime, and there were a number of issues in the basement that didn't meet the requirements that they were looking for. So in our professional opinion, the place that we ended up with is the right place to put this space. And we needed a way to get up to it from inside the house. So we added this connector piece. And the connector piece is sort of the minimum amount we could put in there to achieve a set of steps that meet the building code. And so if the Bruggies needed to get upstairs to their kids quickly, they didn't have to go outside or through the garage space and shorten the space inside the garage. They could just hear the kids, go upstairs and take care of them, come back down all in not without having to go outside. So in that case, maybe just to also just, we only got this letter from Mr. Burley yesterday at 3:27. I had a Hyde Park Neighborhood Council meeting last night. I didn't get a chance to start getting into it until this morning. I'll do my best to try to stick to their comments and explain and clarify what I think they're misunderstanding here. But if I'm getting off base or repeating myself, just let me know. But would we have control, or would you have control of the documents so we can show those as well?
Yeah, you mean to show them on the screen?
And we could, yeah, if you're able to give us access to the screen, we can pull the drawings up, so it might be easier to explain.
Yeah, so I found that it's best if you pull up the documents. That way you can control the cursor and control what's being shown and what you're talking about at that time. You already have permission. All you need to do is towards the bottom, hit share screen. There you go.
Okay, thank you. I'm gonna borrow that. So as I said, and maybe to help save some time, I think from what I can read, there's no opposition or question about the front porch replacement here that we're planning on doing. So I prefer not to spend a lot of time on that. However, that is one of the areas, you know, as we looked at all sides of where we could add, we can add out this way for setback reasons. The driveway comes down through here and there's an easement over on this side over here. And so we couldn't add over here. This area is where the garage and the garage apron, parking apron is. We couldn't go back this way. So we didn't want to fill in egress windows to bedrooms and things like that over here. This made the most sense logically, functionally from the inside, and architecturally to put the space over here. That's the sort of minimum connection space that we came up with. In the plan, it works. Try to find that drawing quickly here. So inside this mudroom here, they could go out. We just enclosed this with a door to get in and out, and a set of steps that go up to the second floor area above this garage here. So we didn't have to do a lot of modification on the inside of the house. We're going to pour a small foundation right there to support the stair hallway right there and connect this piece here. The perimeter of this part of the house, of the garage, I should say, remains the same. So from our point of view, that the variance will change nothing in terms of sort of going through their letter there. But we don't see where there's going to be any change to the character or the quiet nature of Principio. There will be no additional traffic, as someone tried to indicate there. I mean, their kids are going to be up there. If a kid gets dropped off, that's pretty normal for, I think, any household, that somebody comes and drops kids off and leaves, but they're not running a business out of it. They're not having renting it out. There was some comment in there about an ADU. We've never had a discussion about an ADU, additional dwelling unit. It's a room for their kids. Their kids are growing. More kids are coming over to play. The kids are bigger, a little bit noisier maybe, and they're upstairs up there. They don't have to clean up the mess when the kids are done, and it's out of sight. So that was the basic program for this, and what this is all about. But to imply they're going to rent this out or make an ADU out of it, and frankly, I don't think that the legislation on the ADU is defined yet and approved. As of last night, Councilperson Keating said she didn't even know when the hearing was going to be for the council to hear it. So I just don't think that was not part of our consideration. It had nothing to do with this. The addition part is, I think it was described as drastic. It's not drastic at all. It's very minimum. It's a minimum set of steps to get up in and get into the space here, and the cross back and forth over here. So I mean, certainly I've seen much bigger additions, much bigger connectors and those sort of things. We really, this line was existing and this line was existing, and all we wanted to do was connect the two. That's it. So,
yeah, Mr. Malk, if I could ask a quick question on that, is the purpose of that connection just the convenience of not having to not go outside to get to the upstairs room in the garage?
Correct.
Okay.
So that if you had, something happened and you need to get up there, you go up here. You don't have to go outside in the rain, the snow, or whatever. The kids can come down for lunch, go back upstairs. They don't have to go through the garage, open the garage doors, or come through here, modify and reduce the usefulness of the garage, or build something over here that had outside steps to it or whatever. I mean, it just seems to make sense.
Is this the proposed like recreation room, bedroom?
Well, their kids are around 11 or 13, I think, plus or minus. An art room, a playroom, a TV room, all the things kids do that they need a big space for, and for their friends to come over. I don't know what other things might be done in there, but that's the extent that we talked about.
Okay.
Is there a worry about something that would be done in there?
Just curious if there are going to be certain utilities proposed inside.
Well, there would certainly need to be.
Look, these permissions run with the land. So if the Brugge's were to sell this and the ADU legislation passes, there would be, I think, very little standing in the way of another property owner turning this into an ADU. And so I was just curious what the sort of utility hookups, whether there would be a restroom, any sort of kitchen or kitchenette, anything like that up there.
Yes, there will be a bathroom in there, and a furnace. You know, it needs to be heated and cooled. It's part of the house.
Sure.
Condition, if you will.
Okay.
Yeah.
But no kitchen area?
No, we didn't talk about a kitchen area or anything like that.
Okay.
They have a great kitchen down on the first floor. They don't need a second kitchen, I don't think.
Yeah. Okay.
Okay.
Thanks.
So I want to address this question about the shadows. This is going to cast a shadow and prohibit neighbors from enjoying their backyard. And I can't imagine that anybody who went over there and looked at their yard could say that somehow they're going to not be able to use their backyard here. I went over today at 11 o'clock. Their whole backyard is in shade by their own trees, not by any trees on the Brugge's yard or anywhere else. There's a small area up near their house that had some sunlight. But from morning, it looked like anyway, from morning till at least 11 today, their yard is totally functional. It's still in the shade like it's always been. Brugge's aren't impacting that. We did this shade study. We didn't account for the trees in the shade study as we didn't plot the trees and measure the trees, but we did want to see if, you know, where the shadow lines were going to go. And there is no significant change to their use of their backyard through sunlight or shading. So as far as the height goes, you know, if you and you can see maybe I'll pull up our drawing here.
Zoom out.
Zoom out and let's see. Here, can you do that for me? Thank you. So you can see there how we shaded it to show the extent of it, but in the back would be the southeast corner. The gutter line is, you know, below eyesight right there. And we're adding basically a you know, standard 8-foot wall on top of the framing, and then going up from there, we added a dormer to the back and some interest in the back wall facing the neighbors there, trying to make it interesting. Not just the plain wall and plain roof that's there now. And so architecturally, it seemed to, you know, to make sense to match the style that's there, to align the rear wall or the side wall, if you will, for the stair area and match the roof plane. As far as noise and privacy, I mean, it's actually less noisy if kids are playing in the courtyard, the parking area, if you will, the blacktopped area. We just closed off a big area there where the noise can come through. So I think it actually gives the neighbors more privacy, but both visually as well as noise from the other side of the lot. So that, you know, height wise, it's not as tall as the main house there. You can see in the top left, you can see the main house right there. The wall is not as big as the wall the neighbors see, which, can you pull that photo up, please? But basically, there's a 2-story wall facing the neighbors
That's the panorama.
has some very little. Yeah, that's not the one I'm looking for, but we'll find it here. There you go. So they see that wall, you know, from their side over there. That's the existing wall, steps, and patio. That's not changing, and that's, you know, we didn't think that wall. We're not as tall as that wall, and we're further away from where they would be at their own outside patio area. So in our mind, our solution is I think the guy said we called it an eyesore, our design an eyesore. I don't know what architect would do that, but anyway, we think this is a much better solution than actually looking at what's there right now. So in that case, the height is sort of what the height needs to be to make the room upstairs. And we matched pitches and added that dormer. We pushed the dormer back so the wall is not as tall, but yet allows for natural light in. There, the bottom right picture. Yes, right there. We did not put, there are trees there right now, but we didn't show those on these construction drawings. But in reality, that side would be planted as well. And we did show, there were some comments about, we showed some circles, but no species or that. Frankly, I think Mrs. Brugge talked to the neighbor and they talked about, we're happy to put some landscaping in. You know, maybe the neighbor has some comments of what kind of trees, and I think the Brugges would be open to what kind of landscaping to put in there. But all along, we've talked about screening that with some kind of vegetation along that side there. The use of the property is, you know, it's SF10 zoning, and it's going to remain that. It's not really changing anything. It's barely changing the footprint, only in the connector space. But you know, 7 years ago when the project was built, they needed a garage, right? And now as kids grow and get bigger, you know, I see it many times with our clients. They don't anticipate what's going to happen with their kids as they get older. They have us designed for, you know, kids that are 5 and younger, and we keep reminding them they're going to get older and they're going to bring kids over. They're going to be tall, bigger kids and that sort of thing. But kids grow, and now they need this access. And that's what, you know, they need a place for their kids to go. That's why it's like this. So, you know, to take 7 years off of those kids, 13 and 11, I think the kids were small. It wasn't really top of mind to them, and now it is. And so that's sort of why we're here. But as I said, in the hardship side of things, they said there's no hardship, but I think there is a hardship. And I was explaining that at the beginning there on this with the site plan. Where else can you put some more space here? You can't go up the main house. You can't go to the west. The driveway area makes no sense. You can't go to the south where the driveway is and the garage. You can't go north to the front. This is the logical place to put it, and that's why we put it there. We spent a lot of time and a lot of the Brugge's money trying to figure out the best place to put this. And we think this has the least impact and the most benefit for the space that they need on their site. And we think it has very little impact to the next door neighbor. The other neighbors around there, I think some submitted letters. It doesn't bother them. There was some question about whether, you know, why over the top of the garage. Well, there are plenty of examples we submitted of projects that have space over a garage. It's not an uncommon scenario for a house to have this. So this is not some unique design that nobody has or is causing a problem. They're all over the place. And we certainly weren't talking about their setbacks or their dimensions. It was just to show someone that this is a common thing in this neighborhood and in other neighborhoods in the city of Cincinnati as well. So we don't see where that, you know, looking at that is bad. You can drive down the street and see it in many spots. We just got the ones that were sort of close in a radius around this project, but you know, you can see these all over the city. I think, you know, most of the neighbors aren't even going to see this from the street. You really don't see it much. The neighbors that are on the west side and south side there, they see it. They don't have an issue with it. I think, you know, nobody likes change, but I don't think this is going to have what they term drastic effect on these neighbors like they might think it is. But and we're here to answer any questions they might have about it as well. But if we want to go through the Duncan factors, I didn't agree with their Duncan factors either. So is that something we should do?
That's up to you. If you feel like you'd like to respond to their arguments, I think.
Yeah, I think I would, if that's okay.
Sure.
Just so you know, I spent 10 years at City of Madeira Planning Commission, council meetings and zoning. I've gone through these Duncan factors with people till I'm blue in the face, and I know that everybody can interpret them differently, but I think it's important that we respond to how we would see the Duncan factors. The first one, whether the property in question will yield a reasonable return or whether there could be any beneficial use of the property without the variance. We would say yes, but if there's increased value, which we think there will be, typically that value benefits everybody in the neighborhood. So they in fact are improving the neighborhood if they do this project. If I go back to the question later on about tax abatement, the Brugge's did not ask for, I'm not their lawyer, their tax lawyer or their accountant, but they didn't ask for tax abatement on the garage. They did at an earlier stage when they did some remodeling in their house. Certainly the purpose of tax abatement is to keep people in the city as well as to encourage people to improve the property that they already have. So they're certainly entitled to tax abatement. We never talked about tax abatement on this, but because one person likes tax abatement and another doesn't seem to be a reason to deny this project. Duncan factor 2, whether the variance is substantial. We say no, the variance would allow the height of the garage to increase enough to allow access from stair and provide usable space, but it's not a monumental effect to neighbors as it was indicated. It's just not that big of an addition. Number 3, whether the essential character of the neighborhood would be substantially altered or whether adjoining properties would suffer a substantial detriment as a result of the variance. We would say no, the character of the neighborhood would not be substantially altered. I don't even think it's altered at all. Most neighbors feel that there would be no adverse impact on the surrounding neighborhood. If you look at the list of people who submitted things, except for the adjacent neighbor who's on the call today and feels it is. Number 4.
I mean, could you talk a little bit more about that? I mean, do you think that there's any detriment at all? I mean, I think.
I don't think there is to the
So,
adjacent neighbor. I'm trying to figure out if somebody could tell me what it is other than just saying it is, but they can sit out there, they can park their car, they can do all the things they're doing right now in their yard without any, I can't think of anything that they can't do.
Yeah. I mean, you mentioned privacy earlier. Do you think that there's any
This is more private.
impact to their privacy having a second-story window overlooking their backyard?
The
height of the window is so high that people would not be able to see out the window into their backyard. It's a dormer, a high dormer on the elevation.
Okay. How high is the window from the interior?
We'll pull it up here for you.
Sure.
So a person's head would be at this location in the window. This is in the stair. That would correspond to like right here, which is below the sill of these windows. These windows are only there to provide daylight into the new second floor space.
So in other words, they're on the bottom left picture there, you couldn't look out those windows until you got to the landing, and then you'd sort of have to hang out a little bit there to look back over towards that area. I don't think people, I mean, right now you can just come out of their house and see straight over there. This addition blocks that view, but those lights are there to get light into the stair area, not to look over at the neighbor's house. And the same with as Alice was saying up there, that the height, to stand, the kids would have to get on a stool or something, I guess, and look over
Ladder.
a ladder, if you will, and get over there to look out. But those are high windows.
Okay.
So just so we can be more clear on that, what is from the garage floor, or
This is
the
the second
space floor up there, the gutter line is what, 7-11, I think?
Well, that's from the existing gutter line to the new gutter line.
No, I mean, what is it from the floor line to the sill of that window?
Probably 7 feet or more.
So, roughly higher than a door, I think it is, than, the top of a 6'8" door or whatever. So it's not a viewing area, right? It's just to get light in, not view out. Does that make sense to you?
It does.
Okay, thank you. Okay, so let's see, I think I was on number 4. Whether a variance would adversely affect the delivery of government services. No, there's no effect on any of that. Number 5. Whether the property owner purchased the property with the knowledge of the zoning restrictions. I don't believe they did when they bought the property. I think they learned of some when they did the garage, as it was mentioned that there was a question about it from the zoning review when they did the garage work. I don't think they were thinking about what was going to happen in the future at that time and whether it was going to have any impact and what that even meant to them. Of course, now we're here asking for a variance, so certainly they know about it now. Okay?
Yep. I'm following along. You can move forward.
All right, and I'm looking for 6. Yeah, 6. Whether the property owner's predicament feasibly could be obviated through some method other than a variance. I think that's what I was trying to say earlier, is we did an exhaustive analysis of trying to find the best place for this. And this is the most logical place to put this space on this property without any impact to the architectural character, to land coverage or any other criteria you want to look at. It just made sense. It just so happens that the zoning code setbacks do not allow this to happen, and that's why a variance process is there. So when those things aren't feasible, there's a way to relieve that from the homeowner, and that's why we're here. So
So let me dig in just a little bit here on this. So
Yeah.
so the condition that's giving rise to the need for this variance, you're saying is a growing family and growing children. Is that right?
I think that's fair. Yes, that's what we were saying.
So if that is the reason, wouldn't that then sort of give anyone that has a growing family or growing children the ability to get a variance from the zoning code to do similar things? And
I think I understand the idea of precedence, but I also think that the reason that there's a variance process is for those unique sites that the code does not make any sense for what they're trying to do. And so you can go and ask for a variance to those things. And of course, you have to evaluate the pros and cons and the impact. And I think what we're saying is there's very little negative impact for anybody with this addition here. Whether they wanted to put a ping pong table or have a place for Thanksgiving or whatever, I don't know that the specific parts of that matter. What it is they need some more space for their growing family. That's pretty much what it amounts to, and this makes sense.
Okay.
Hey, David, if I may, sorry to interrupt, just to add a little color from the homeowner side of this, if I can.
Mhm.
where we were really, in what, to Mike's comments earlier, our original plan, so our house, what wasn't conveyed in all this is our house has been added onto twice. It's like a 1910 farmhouse. And I think in the 70s, somebody added on a 2-story addition, but instead of digging a basement for that, they made it all crawl space. So when we did our first addition back in 2016, we did it on the back of that addition. And so you couldn't add a basement and then have be a basement, crawl space, basement. It just structurally wasn't sound. So we had to add more crawl space. So what happened is our pretty much 3/4 of our house, there's no basement underneath it. And the quarter that is, 1915 or whatever the house was built, basement that is just, and so what we thought originally was, let's see if there's a way where we can underpin the house, dig it out so that we can have it be where we can actually have a ceiling and people can be down there and turn it into, what a normal family has as a basement where the kids can go hang out. And as we went through iteration with Mike and his team, it just structurally wasn't sound. A, there was a lot of risk to that, and B, the cost was just massive. And even there, we risked the structural nature of the house. So we just said that, that probably doesn't make sense. And so that's where we went back to the drawing board of, okay, well, where can we create this, hangout space for the kids that normally would be a basement? Where could that be? And that's where Mike and his team were creative enough to come up with the thought process over the garage. So I'm just giving you what kind of our rationale and thought process was. I mean, to Mike's point, we started this process 2 years ago, and architecturally, we're probably $30,000 to $35,000 in on fees. So we have exhausted a lot of energy, time, resources to try and make this as palatable to everybody involved. And even Molly, my wife, has shared the plans and the idea and the updates with Lori Wood many times through this 2-year period, and really no negatives were given to that until we asked for a signature on what were completed drawings by Mike and his team to take it to the variance committee. So I just think I wanted to give you that background from our perspective on really the evolution of how we got here. And why we got here. It wasn't just that we wanted to put the space there. We just, we're looking for a place for my 11-year-old and 13-year-old to hang out with friends that, wasn't on top of mom and dad in the same family room where mom and dad are. And this is really the only place that architecturally and structurally that we could figure out a place, and Mike and his team could figure out a place to make it happen. So sorry to interrupt. I just wanted to add that.
Thank you. I appreciate that.
All right. Thank you, Kevin. So number 7, whether the spirit and intent behind the zoning requirement would be observed and substantial justice done by granting the variance. So we say yes, that the spirit and intent would be met if you granted the variance. I see it's done all the time in Hyde Park zoning committee work that I do. There's just sometimes that the zoning code doesn't make any sense to a particular site or a particular project, and the best solution doesn't meet the zoning code, and that's why we're here, and that's why there is a variance process to go through. That all these other, to work within the existing zoning code without a variance, which RWA tries to do on 99% of our projects, but when it comes up to there is no good solution other than asking for a variance. We explored all the options that we could and how to make this as best we can, and still need a variance. So in our case, we're still waiting to hear why this is such a bad idea, and why after going through the Duncan factors, it still makes sense to us. So I guess what I'm getting at is that's sort of our presentation, right? I mean,
Sure.
I think we've answered why we started, how we got here, what we tried to do to make this the best project possible, how to make it beautiful, functional, how to work with the site, all those sort of things. And I think that, yes, it's different. It's going to be a different view. It's not a bad view by any means. It doesn't prohibit the neighbors from doing anything that they're not doing today or have been doing. And so until I hear something, there's nothing else to really respond to, I think.
Okay, well, that sounds like maybe a good prompt to hear from the neighbors. However, before we do that, I think that Mr. Burley is entitled to ask a few questions of you or the owners, if he has any. Mr. Burley.
Mr. Examiner, I'm happy to proceed however you like, but we do have not only some questions for the architects on this matter, but also the property owners themselves and the plans examiner that wrote the staff report for this matter. So if it would make more sense to do all of that questioning at once, I'm happy to do so.
Let's do that. Although you cannot cross-examine government officials, and so I won't allow any cross-examination of Mr. Menzel, but you can ask questions of anyone else.
Okay. Well, I would object to that just for the record. We would like to cross Mr. Menzel. Not
Noted.
Understand your ruling. Thank you.
Noted. Floor is yours.
Well, good afternoon, Mr. Examiner. Again, my name is JP Burley. I'm with the law firm of Suter LLC, and I'm here on behalf of Mr. Anthony Wood and Mrs. Laurie Wood, who live at 3453 Principio? 3459. 3459 Principio, I apologize, which is directly to the east of the subject property in this application. And to be clear, they have no issue with the special exception for the front porch. That's fine with them. What they do have an issue with, Mr. Examiner, is the garage expansion in the side yard setback variance. And I don't know if you had an opportunity to read our written statement, but I would encourage you to do so before you do make a decision in this case, because we feel that this will cause some serious adverse impacts to the abutting property owner, and the legal requirements for a variance simply are not here in this case. As the plans examiner himself noted in his staff report, there is no hardship here. There is no good argument for property rights here. All you've really heard from the applicant is that we'd like more space. We don't think it affects anyone, and we've already spent money on this, so please approve it. As you noted, Mr. Examiner, if that was the test, anything could qualify for a variance, but there are specific rules and standards that an applicant must meet that have not been satisfied in this case. The applicant is looking to essentially annex the existing garage, which is less than 4 feet from the Woods' backyard, onto the principal structure. They're essentially moving their entire house into within 4 feet of the Woods' backyard. They're going to add several feet on the front end of the garage, and they're going to effectively double the height. This is going to have a significant impact on the Woods' use and enjoyment of the backyard. As you will hear from them very shortly, the backyard is a crucial piece of their enjoyment of their property. This is one of the core reasons why they love their home, why they love their property, why they have so enjoyed living here, and why they hope to remain for years to come. But if this variance is approved, essentially allowing the garage to double in height and move the principal structure within 4 feet of their property line, this garage is going to tower over their backyard. That creates significant visual impacts. That's why there are separate setback requirements for setback and height requirements for accessory structures versus principal structures. It will have light impacts. If there weren't any, then the applicant likely would not have created a shadow study. I mean, they've essentially admitted that it's going to block out sunlight. And likely there will be lights in this upstairs window. They will be on, they will be aimed directly at the Woods backyard. That's going to create light impacts as well. And converting the structure essentially into living space. And that's what you've heard, that they're going to use this as living space, is undoubtedly going to create more noise impacts than currently exists on the property. And you haven't heard any details on how they're going to mitigate this. There's landscaping marked on the site plans, but no details as to what that landscaping is going to look like. Unless you put fully grown, dense tree coverage here, there's no way to mitigate against these obvious concrete impacts to the woods use and enjoyment of their backyard. And it's worth noting, Mr. Examiner, just what extraordinary relief they're asking for. Mr. Mauck, I believe, stated that the only reason the connector is being put in place is for the convenience of not having to go outside. That certainly might be more convenient, but what it also allows them to do is escape the height requirement for accessory structures here. If this wasn't attached, there would be a 15-foot cap on the height of that garage. By attaching the garage to the principal structure, it allows them to create an entire second story. And even at that point, it's still not permitted by right, because the side yard setback is 10 feet for SF10, plus an additional 1 foot for every 10 feet that the principal structure exceeds 60 feet in depth. So assuming that the staff report is correct, that this leads to a 15-foot side yard setback, although we're not sure whether there was a typo in that staff report, and that was one of the issues we had hoped to get at today. Even if 15 feet was the required setback here, that's a near 75% reduction in the side yard setback. You're essentially moving the principal structure within 4 feet of the woods property line. That is a huge request. And it's for no other purpose than to allow the owner more living space.
JP, real quick, you're questioning whether 15 feet is the appropriate setback?
Yes, Mr. Examiner.
Okay, gotcha. Just wanted to make that clear. Wes, if you can take note of that and respond. Sorry, JP, you can continue.
Yes. You haven't heard any mention of topographical challenges or constraints. There's nothing unique about this lot whatsoever that would give rise to special circumstances or practical difficulty. The owner has already made a very beneficial use of this property. At the time that they bought it in 2011, the auditor had valued this at $433,810. In 2021, the auditor valued it at $818,580. That's an increase of $384,770, or an increase of 88.6% in the decade that they've owned this property. So to say that they don't have a beneficial use of this property is simply not accurate. They've made a very good investment here, in part because of the significant improvements they have already made. And it's worth noting, Mr. Examiner, that those improvements themselves have created the limitations they're now seeking relief from. The addition on the rear of the house, the location of the existing garage, they chose those. They built those structures. The layout of this lot is almost entirely of their own making at this point. So there's nothing unique about this lot. If there was, it's created by the applicant. And there's no substantial property right at issue here. What you've heard a request for is essentially additional living space, which I understand that would certainly benefit the property owner, but that's not a substantial property right in the variance sense. Locating a 2-story garage and living space less than 4 feet from the woods backyard is not a substantial property right. And again, the staff report agreed that this is not a good case for hardship. It's not a good case for property rights. As far as we could tell in the staff report, approval was recommended simply out of a perceived lack of adverse impact to neighboring property owners. But as you're about to hear from the woods, there is significant adverse impact here. And even if there wasn't, they haven't met just the minimum prerequisites to receive a variance in this case. There's no public benefit here. It's only private advantage for one property owner that wishes to be treated differently than similarly situated property owners. That's not practical difficulty. That's just special privilege. So the applicant has not satisfied any of the legal requirements. And so we would respectfully ask that you deny the side setback variance requested. We do have several witnesses to call in this matter. First, I would call the Woods. Mr. Examiner, do you have any issue with me asking them questions at the same time so that they could testify together?
Sorry. No, I don't. That's perfectly fine. And you're happy to ask them questions directly or to just let them testify on their own. It's really up to you.
Okay. Thank you, Mr. Examiner. So, Mr. and Mrs. Wood, would you first just introduce yourself for the record, spell your names, and how long have you owned this property?
My name's Anthony Wood, Anthony, Wood, WOOD. I believe we bought it in 1998. Yeah, you spell your name, please.
I'm Lori Wood, LAURIE, WOOD.
Okay. So you bought the property in about 1998, you said?
Correct.
And tell us about how you've used the property.
Well, I would say the reason that we purchased the property is it's a solid house. It's there's nothing particularly good looking about it. I mean, it's a nice house, but it's a wonderful location. We love Mount Lookout. And, we've always wanted to live there. Actually, our house previous to that was less than a mile and a half away. The reason we purchased the house, and for like a lot of people, we spent a little more than we would have liked at the time, was because of the backyard. It had a deck at the time. My wife likes to garden. We had small children at the time. That was really the main nice thing about the house. And over the years, we have tried to build upon that, in that we've put in a screen porch so that we could spend more time out there. So it's basically we're out there 3 seasons out of the year. We also have done an extensive amount of landscaping, and as I said, my wife is a big gardener and she's very interested in it. And we recently put in a very expensive concrete driveway, once again to try to play up the beauty of our backyard.
And do you have children?
We do. They are out of the house now, but we raised them there, and we use the backyard for. It's a little hilly back there, but
So we had basketball back there. The kids played baseball, soccer, and we used it for sledding.
Yeah,
It's a good
it's a
sledding
good sledding hill.
How often would you say you're in the backyard?
Except for
Well, we are every day with the dogs.
yeah, we have 2 dogs, so that's also a big factor. We're out there literally every day.
We
we're
eat,
home.
we eat dinner out there, and during the day, I just sit out there reading, or, I mean, you can even sleep out there.
Right.
So we're out there a lot, on the porch, in the yard. We have, we're lucky to have 60, 70, 90-year-old trees in our backyard and in our front yard. And we have bird feeders. I enjoy that. So I'm always looking in the backyard. All our windows are in the backyard, that we see the garage. So now we see that we're going to see, can I say this? We're going to have a 2-story house 4 foot from my property line. And the Brugies have a wonderful 2-story house, and it's far enough away that you don't notice. But if you put a 2-story house above this garage, it's going to look like they have 2 houses in their backyard. And the new proposed house is going to be, correct me if I'm wrong, but I think 4 foot 8 inches below the original house. The original house is a 2-story farmhouse with an attic. And it's very tall. It looks fine where it is, but it wouldn't look so fine up against our backyard. But to go on, we use our outdoor space all the time.
And do you recall when the Brugies bought their property?
Kylie would have been around 1. So Kylie's 13. About 12 years ago, they bought the house and they renovated it before they moved in. And then I think 2016 was the big addition where they bumped out the back of the house to add on to the family room. They have a wonderful family room. And then they put the garage. Now, we're not architects, and we don't know the building codes. So we never questioned when they put that in. It was like, it's their yard, it's their business. And then later on, so it was built in 2016. And to answer your question, Kevin, Molly and I started discussing dormers going on the garage. Do you want a dormer on your side, Lord? No, I don't. So we were envisioning the current garage with dormers.
Going the other way. Going towards their property, right?
But their property and our property.
Okay.
And so I was thinking, well, I really don't want a dormer on my side, but it's their property. So we always just thought that this, originally it was going to be a place for her parents or somebody's parents to live. And we discussed where to put the elevator. And so since 2016, we've been just not all the time, but just occasionally. So all we were aware of was they were going to maybe put in an elevator. They were going to make a space for somebody's parents, and it was going to go in that space above the garage with dormers. And then it just got bigger.
Would you say you've gotten to know the Brugies fairly well since you two have been neighbors?
We do. They have wonderful children, and they've been the best neighbors.
Have you been in the Brugies home?
Yes,
Do they have a living room?
yes,
Do they have a family room?
very nice.
Are those separate spaces?
Yes.
Is there any other space for socializing or relaxing in that
Well,
house?
I agree that the basement is limited. It's a 1910 farmhouse. Tony and I always thought they were going to do something to the top floor. It's a beautiful 2-story farmhouse with an attic. And I know the kids did play in there, and we just assumed they would do that. Kids play area there, parents over the garage. And like I said, it's their home. They should do what they want, but not 4 foot from our yard.
So before they bought the property, there was a garage on that lot, correct?
A 2-car garage with I think it had a side door.
Where was it on the lot?
It was kind of in the middle,
back.
maybe 30 feet in the back, right in the middle. And it was fine. It's always been there since we were there.
And what happened to that garage?
They took it out.
Was this around the same time that they put the addition on the back?
I think so.
Was the existing garage built around the same time?
The existing garage was built in 2016. That's what my memory of it is.
And so how did the construction of just the current garage affect your view in your backyard?
Yeah, I'd like to address that. We actually have a picture. I hadn't remembered this. So there was a garage, the existing garage when the Brugge's bought that house was directly behind the house. And it wasn't a great garage. I think it had a shed roof. It wasn't very good looking. And so they said they were going to tear it down and put in a new garage. And I just didn't even really think too much about it. You know, they told us, and said, okay. And but they took it down and they changed the location of the garage. And I have to say, it looks great from their side. I mean, it looks awesome. And but we used to look out into green space over there. Now we look at a vast expanse of asphalt shingles. And I'd forgotten how good it used to look. I mean, it looked awesome. I mean, from our perspective, we just got to look at, but you know, it's their property. They made a decision, and we counted on the city of Cincinnati to make sure that they, you know, that they were within the zoning codes. And I think that the city did do that. You know, they are allowed, as far as I understand, it's a 3-foot setback for a detached garage. And so they put it in, and you know, we just had to kind of live with it. And that's fine. But this time around, we were actually asked our input. And we would like to say, no, this is way too big, this close to the property line. And we didn't ask them to put it 4 foot from the property line. They could have put it 10 foot, you know, which I think by that time wouldn't even be here today. So we were asked for our input. And, you know, that's when we decided, you know, maybe you can do whatever you want over there. Just don't change the existing roof line. Do whatever you want. Well, that's not what happened. That roof line is going to be 4 foot, what is it?
Well, there's a photo.
Mr. Examiner, we submitted a picture in our written statement that illustrates about where the new gutter line will be in relation to the existing gutter line.
7 feet 11 inches.
Yeah, is that the picture with the person holding up the
Yes.
broom
Yes,
or whatever that is?
That's Mrs. Wood. And
Okay.
that pole represents that 7 feet 11 inches, which is our understanding from the application, is the increase in height for the gutter,
Just the gutter.
just the gutter. It does not include the actual roof or anything above it.
And I would say as a final, I mean, Lori, I'm sure will have something to ask, to add. I completely understand, you know, my understanding of what variances are there for is that, you know, there was a time in Cincinnati when there wasn't really a zoning code, as I understand it, and people just did what they wanted. And, but as things changed and things evolved, the zoning code was put into effect. And the zoning code was put into effect because there are people who had a 1910 farmhouse that had a garage that was very close to their neighbor's property line. And they had no input on where that garage was. That's just the way it was. And that was before the zoning code. And so it's unfair for those people to have to, it's an unfair burden for them if they want to do something with that existing garage. This garage was built in 2016. So I don't understand how the variance system works for this. When we bought this house in 1998 and moved into our neighborhood, moved into that house, we didn't think that our next door neighbor could put in a second house 4 foot off the property line, because that's what it is. It is a second house.
Laura, do you have anything to add about how you feel about the scale and use of this proposed garage expansion?
I had some questions.
Who did you have questions for?
I have a question for the architect.
Is there any way that you could communicate these to your attorney, Ms. Wood, and
Sure.
your attorney can
I'll
ask the
add
questions?
some questions,
Oh,
so
gotcha.
I'll just add that. Okay.
Just the window.
Yes.
Sorry.
Yes. Okay. Thank you.
And JP, I think this is just a good time to move into cross-examine generally, and I'm gonna limit it to 5-10 minutes.
Thank you, Mr. Examiner. We would first call, since he was the one speaking, Mr. Kevin Brugge, please.
Sure.
Good afternoon, Mr. Brugge.
Hello.
You bought the property in July of 2011, correct?
Correct.
And when you bought the property, there was a garage at the rear of the lot where the gravel area and fire pit is now located, correct?
Correct.
And the house itself was not as deep as it is now, correct?
Correct.
You demolished that previously existing garage and built the current one, correct?
That closed-in carport we demolished, yes.
And you worked with an architect to design and locate the current existing garage, correct?
We did because it couldn't fit 2 cars.
And you added an addition on the back of the house, correct?
We did.
And did you add on the driveway overhang, or was that already there when you bought the property?
That was there.
And so to be clear, when you built the existing garage and the addition on the back, did you sign off on exactly where these things would be built on your property?
I'm sure we did, yeah.
Okay. Now, because of all this additional work, the auditor apparently believes your home is worth significantly more money than when you bought it.
Well, we put $500,000 in, so it's actually lost money in terms of a return, but yeah, it's worth more. It should be. We added more than 1,000 square feet.
Do you know what the total square footage is today?
Mike, could I defer to you on that? Is it maybe 23,000? I don't know.
We did not calculate your square footage. I couldn't give you an
I
answer.
think it's 2,900 square feet is my recollection. But I don't know that. So, if you need a factual amount, I'm not positive.
So you're aware that at least the auditor believes your home has increased in value approximately $385,000 since you've owned it.
Yeah, because the investment we put in. So again, it's lost money in real terms, but yes, it has.
Sounds like a pretty good investment.
No, it's been a terrible investment. It's lost 40% for what we put in it. But it's added value to the community, obviously, because it's now worth $800, which is great for the neighborhood. It's allowed us to have a growing family there, and it's we think most neighbors that come over really enjoy the space and they love it. So it's been great for the community is probably the better way I'd say it.
So the application contains some language about taking care of elderly parents. Whose parents are those, please?
We really don't have any elderly parents. Molly's oldest parent is 75. Both my parents, I have a dad and a wife, and he has a wife, and they're in their 60s. So nobody's elderly. Well, it depends.
Well,
on
the application references elderly parents. So which set of parents were you referring to, or is it both?
I mean, I guess it would have to be Molly's parents. Sorry, babe.
And do your wife's parents live nearby?
They live on the west side of Cincinnati.
And so is it your hope that they could someday live in this space?
That in conversations with in past, that might have been like, if somebody needed a place to go, then by all means, we want to make sure our parents are taken care of. So, and we're blessed that we've got resources to be able to help them, but there's no imminent idea. I mean, no way Molly's dad would want to move in with us. He loves us, but he doesn't want to move in. But I think if, anybody ever had a really bad health issue, we'd love to be able to take care of them, but it's not going to be a nursing home or where somebody's living long-term. No, I wouldn't imagine.
So you said your property is about 2,900 square feet. How many bedrooms is that, please?
1, 2, 3. 1, 2, 3, 4, 5.
How many children do you have?
2.
Does each child have his or her own bedroom?
They do.
And you heard the Woods testify that you have a living room and a family room and an attic area. Is that accurate?
Yeah, the whole first floor is open though, so they're really not separate spaces. It's all one space. Certainly that was our design, but it's really one continuous space on the first floor. The attic is another, I don't know what you call it, bonus. I don't know what the legal jargon would be, but maybe a bonus room or something.
Is it finished?
It's finished with horrible heating and air conditioning. It's about 120 degrees up there in the summer.
That's all I have for Mr. Brody at this time. Thank you.
Okay. Any other questions for anyone else in the hearing?
We would call Mr. Mauck, please.
Mr. Mauck. Okay, go ahead. And about 4.5 minutes here.
Good afternoon, Mr. Mauck. I have a couple technical questions about these plans. What's the current height of the gutter line facing the woods, both at the north end and the south end of the garage?
Mr. Mauck, are you with us?
Yes, I am. I'm trying to figure out where he's talking about here.
Is that top drawing there?
There's the I guess, if you, at the north, no, I'm sorry, the southeast corner right there, it's about 4 feet. I stood there today. It's about 4 feet.
I don't know what we're talking about.
The back of the garage.
It's okay. All right. And what about at the northeast corner?
East. That is it's right there. It's about at my, it's probably about at my eye height, right about there, stand where I was standing today. So I don't know, 5 feet maybe.
So, and that gutter will increase in height about 7 feet, 11 inches, correct?
Yeah, that's correct. I know you guys keep calling it a 2-story wall there, but it's really not, because majority of the first floor is buried in the ground. So it's really a story and a half popped out.
But if you're talking about visible elevation surface from the Woods backyard, that will more than double, correct?
I haven't done the math on it or looked at it that way. I know they'll see less roof now than they do right, or when this was built. If this is built, than they do right now.
So if the southeast corner is approximately 4 feet high right now, and you add 8 feet, is that 12 feet altogether?
Something like that. Yeah, that makes sense.
Is that more than double?
Yeah, it's approximately more than double. Yeah.
How
I mean,
deep-
if I got 1 foot and I double it, that's 2 feet. I'm not sure what the doubling has to do with it, but it's whatever number's there.
And how deep will this connector space be as measured from the street?
How what?
What is the additional length of the garage you are proposing? How deep is the connector space?
Approximately 6 feet.
6 feet? Additional length on the garage?
Fills in the space.
Yeah, whatever the
between-
distance is between the garage and the house, that's what it is.
So the garage is going to be 6 feet longer if this work is approved and completed. Is that
Well,
your testimony
Not the
today?
garage itself. The garage doesn't change in size.
It's going to be one continuous elevation, isn't it?
Correct.
Okay, and that's going to be 6 additional feet longer.
I think that's correct, right? It's on the plan,
Okay,
The connector.
the connect piece.
and once the garage is attached to the principal structure, it's all going to be one structure for zoning purposes. What will the square footage of that structure be?
Go to the plan. It's whatever the existing garage is, plus the 6 feet. The length, and then the existing width is the same.
Do you know what that total amount is, please?
I no, not in front of me. I'd have to go to the computer and take it off, but no, I don't.
And so you testified that you're barely changing the footprint. And so you don't actually know whether that's true because you haven't done the calculations, correct?
Well, I mean, I can see it right there. You can see it. It's not much at all. It's filling in the gap between the.
Mr. Mount,
Yeah.
you said the only purpose of the connector was so that persons at the property would not have to go outside. Isn't that what you said?
I said it's a connector between, yeah, so they don't have to go outside to get up to the second floor.
You said that's the only purpose, correct?
Well, the dog might be in there, or they might put the garbage can or something in there. I don't know, but it's.
But
That's
Mr.
what-
Mount,
Yeah,
you already explained how you have dealt with the Cincinnati zoning code extensively. And
yeah.
so you understand that if that connector was not there, this garage could only be 15 feet high, correct?
Yeah, I understand that.
Okay.
To the midpoint.
And so by adding this connector space, you're essentially not just making it more convenient for people to get to this building, you're evading the cap on accessory structure height. You understand that?
It's no longer an accessory structure.
Exactly. It's all one structure of which you have not calculated the square footage.
No, I haven't.
And you haven't submitted a landscaping plan, correct?
No, we haven't, we would do that at a later time, but we indicated there would be landscaping there.
So you don't have any specifics on what plants will go there, how large they will be, how mature they will be, correct?
No, not yet. We haven't even had that discussion on what those would be. They might be arborvitae, they might be saplings, they might be rose bushes, who knows?
Okay.
It's too early to tell.
Now, Mr. Mack, you said several times that this was the best solution. This was the only place for this to go.
It makes sense, yeah.
When you say solution, what exactly is the problem you were trying to solve?
Well, we wanted to give the Bruggies some space for their kids that was accessible from the main house, but also private.
And so is your
JP,
argument,
we're gonna need to wrap up cross here. Give you another minute.
so Mr. Mauk, is it your argument that having private space for children is a substantial property right?
We hear that all the time. That seems to be what people want, especially when they have an open first floor, because the noise can become unbearable.
But to summarize, the problem you were trying to solve was just more space, more living space, correct?
Yeah,
I have no further questions for the architect, Mr. Examiner.
Thanks. Wes, a couple minutes if you'd like to add anything in addition to your staff report.
I just there was a question about the setback calculation, and so the 15-foot side setback requirement is based on the additional depth of the house. Like there's a clause in the code that requires additional setback distance based on the depth. So it's 5 feet more required than the normal SF10 10-foot side setback. So that's where that 15-foot distance came from. And I will add a little bit of a qualifier on my comment about on page 14, there is no hardship presented to by the applicant. In learning today about the fact that there's lack of a basement under much of the house, or maybe the basement floor to ceiling height is constrained because it's an old house, that perhaps there could be a little bit of an angle that there's a basement space is typical for a play area or such entertainment area, and that perhaps the second floor of the garage could be considered a replacement for that space. Just kind of a qualifying point to my comments. Thanks.
Okay, thank you, Wes. All right, to RWA, is there any evidence or testimony that you wanted to present in response to any of the arguments made by the Woods?
no, I still don't see any impact to them in their yard. They could stay out there 365 days and still do the same thing that they wanted to do. This is a beautiful elevation to look at over there. What garage was there before and got torn down seems irrelevant. What they paid for their driveway seems to be irrelevant. I still don't see what the issue is for them with this addition there. And to say that it's a 2-story house, there's 2 houses there, that's inaccurate. It's one bigger house now, or it would be. And as I said, the majority of the first level of the garage, the existing garage, is buried into the hillside. Their property goes up even higher in the back, so it's even less of an issue from the backyard than it is from down sort of in the hole where their garage is, in that area down there. It's no higher than if they turned their head a little bit and looked over at the Brugge's sidewall of their 2nd-story house. I believe was the original farmhouse. I'm not sure what the difference is. I see no difference in that. It's actually higher than what they're going to see at the garage. The idea that somehow the lights from inside the house are going to be directed towards their house, I don't understand that at all. I've been over there numerous times, and I saw him walking the dog on the sidewalk this morning. That's the first time I'd ever seen him over there. So maybe I just missed him or whatever, but I've never seen any kids playing over there. Of course, I'm not over there like the Brugge's living right next door, but the idea that they're living outside, and I think that's great if that's what they're doing, but we're not doing anything to prohibit that.
Okay. So JP, you have an opportunity to make any closing remarks. I will ask that you keep them brief and succinct if you can, and then RWA, you'll have final word if you have anything else after JP's comments. JP.
Thank you, Mr. Examiner. I would renew my request to cross-examine Mr. Munzel, and if you deny that, I would note that objection for the record, please.
It is noted for the record. It is denied. It will
Thank you.
continue to be denied. You are not going to cross-examine Wes.
Thank you very much for your time and patience, Mr. Examiner. The issue in this case is that they simply have not met the legal requirements here for a variance. This is not a forum to voice whether the property owner thinks that this expansion would be good for their private interest or not. It's more than that. There are specific tests that the applicant has to meet, which they have not done. There are no special circumstances or conditions pertaining to this particular piece of property that would allow you to grant a variance under 1445-15A. They have created the layout of the entire rear half of their lot. If their argument is that they don't have space, they created that issue. You heard Mr. Malk essentially agree that this has been a good investment. They are making a reasonable return right now. They argue that the variance is not substantial, but it's only insubstantial from their perspective because they don't live where the Woods live. They don't enjoy the Woods backyard. This is not just a significant impact to the abutting property owner, but it's a massive deviation from the actual language of the zoning code. It's essentially a 75% reduction in the setback variance. This kind of structure does not exist in Mount Lookout generally. That you saw in Mr. Munzel's report that the properties cited are not directly comparable. This would be one of a kind. It would be out of the ordinary. It would essentially be granting special privilege, which is not what you're here to do. And they knew that this was the rule. They bought the property subject to these restrictions. The zoning department made them aware of these restrictions when they built their existing garage. And if you granted a variance from this setback, it would completely negate the purpose of the side yard setback to begin with. So it fails Duncan. There's no practical difficulty here. There's nothing about this property specifically that rises to the level of hardship sufficient to justify a variance. And there's no substantial property right here. They have failed to identify that. Additional living space is not a substantial property right. Private space for their kids to socialize out of sight of their parents is not a substantial property right. Building a 2-story garage 4 feet from a neighbor's property line is not a substantial property right for the purpose of a variance. All you've heard is essentially, this will benefit our family, this will benefit our property. But you have to weigh that, Mr. Examiner, against the very real impact to the Woods, which you've heard extensively, and between a private benefit and a private harm, those cancel each other out. And there's no public benefit at issue here. If anything, it's out of character for the neighborhood. So it's the side setback variance requested is not in the public interest, on top of not satisfying the minimum standards for variances. So we've given you a lot to think on. I will be respectful of your time and conclude, but thank you very much for your time and respectfully ask that you deny the side setback variance requested herein. And I would add, Mr. Examiner, that we did include 2 statements of additional property owners that share the sentiments of the Woods. So they are not alone in this opposition. Thank you.
I saw that, and that is included as a part of the record. Thanks, JT.
Thank you.
RWA, a couple minutes here if you have anything in closing you'd like to say.
So
Mike, if it's okay, can I just close?
you can go right ahead.
So I would just say that, you know, it really is simple. Wes did a really good job of articulating it back. Kind of what our point was is that, you know, we're replacing our basement that we don't have for the normal family living space for two young kids that hopefully will hang out at our house with their friends, that we can know their friends and be there and see it. And that really, it's as simple as all that. You know, the 6 foot and all that. From our angle, that's what it boils down to. And we really tried as hard as we could to make this as beneficial to both sides. And I'm not just saying that to say it. And the woods are important people to us. And I hate going through this process. This is an ugly process, and I know it's going to affect the relationship, and I don't want it to. And in the comment on the landscaping and not knowing what it is, I mean, that's kind of ridiculous, because if you came over and looked at our side yard, it's the most beautiful spot of our house. And it was created by Molly and with Lori's input jointly to create almost a park-like feel. And originally we were going to shutter it with all arborvitaes to give us both privacy, but we both decided, no, then we wouldn't see the woods. And we created a stone path in between our side door and Lori's yard so that we could easily cross between one another and see one another. So they are important neighbors to us. And so I just think, you know, this process on both sides, it's lost that. And I hate that. So I just, from my angle, it's as simple as Wes said, and whether the committee decides it's appropriate or not, we respect your decision 100%. And but that's really what our motivation for this whole thing was. And really the reason it drug on for 2 years is because we kept going back to the drawing board because we couldn't make the basement work structurally the way it was. So anyway, appreciate you hearing me.
Sure. Thank you. Okay, let's leave it at that. I want to thank everyone for their time and their testimony. I know that a lot of preparation and thought has gone into this. And so I've got a lot to think about and digest here. So I'm going to take a little bit of time to review all of the materials that I've received, review the testimony from this hearing, and then render a decision after I've had a chance to do that. I mentioned at the beginning of the hearing that it typically takes about 2 weeks. That 2 weeks includes me making a decision and then also writing out a formal written opinion. And so that as soon as I finish it, I put it into a PDF and I email it to everybody in the hearing. So you all will have a copy of that decision really just moments after it's complete. If you have any questions about the process or the status of the decision, you can contact me directly. I'm happy to give you an update. I cannot at this point take in any new evidence or testimony or information about the project. You know, again, if you have anything that's just procedural, I'm happy to respond to any of those questions. Okay, unless there are any other immediate questions right now, I think we'll end this. I want to thank you all again for your time and your testimony. I hope you have a wonderful day. We are adjourned.